Hey everyone, so Daryl here. Today's question answer, this question we got is what is good corporate governance? Essentially, we didn't actually get that question. But uh, what I got was that one of my clients, right, who is like a one-man show. So essentially, he is like a sole proprietor, but it's a company. So he is the sole director and the sole shareholder. Essentially, there's only one guy in the company. So there's a shareholder and a director, and they are both the same person. So he's asking me, what are the things that I have to do, irregardless of whether I'm just this one man show and whether my business is, very big or very small, and what are the things that I can sort of scale down to a certain aspect. Okay, so this actually is a lot of common sense. Okay, but I usually break up matters into internal and external matters. So internal matters, right, pertain to things like how directors account to shareholders. So internally within the company would have a rule book of how it's run. That would be the company constitution. So you how the company does its business, you have to refer to the constitution, and the constitution would state out very clearly how the directors are supposed to call for meetings, and the shareholders would approve for certain resolutions which are passed by the directors. So these are the things that are internal. So if let's say internal matters like shareholders agreements as well. So that means shareholders and shareholders, if they have this agreement, maybe to have some clauses whereby if let's say one of the shareholders wants to sell to another person his shares, right, his shares to another person, then uh, the 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 current shareholders, right, would have this preemption rights, which means that they have the right to first refusal, or the right to make an offer on the shares, the right to acquire the shares before shareholders from outside the company step in. Okay, so these are what we call internal matters. Okay, and if in breach of a shareholder resolution or shareholder agreement, right? Let's say two shareholders, they sign a shareholder agreement. Then one of the shareholders breaches this shareholder agreement. Then what is the remedy? So the remedy would be that the shareholder who is aggrieved, then he would have to take the other shareholder to court, and then it will be a civil matter. Okay, but there are some internal matters, right, whereby it's also in statute, which means like there are minority oppression, which means that if the majority shareholders do certain actions to oppress the rights of the minority shareholders, then there might be some statutory provisions, right? For example, if I'm not wrong, it's section 216 of the Companies Act that states that minority oppression is not correct. Okay, so it's statutorily enshrined that you're not supposed to oppress the minority shareholders. Okay, so these are what we call internal matters. So internal matters are how the company deals internally among itself, and essentially it is accountability from what the directors do to the shareholders and the shareholders among themselves. So as you can see, right, if let's say the person is the sole shareholder and the sole director, which means that the company only has one individual in this company, then the possibility for matters like internally going wrong, right, whereby shareholders and directors, or directors not accounting to shareholders, these things should not happen. Okay, of course, unless the director or the individual who is both the director and the shareholder has split personality, then that one I got nothing to say. Okay, but essentially the directors every year they have to prepare the financial statements and then show it to the shareholders, and the shareholders will have to approve that set of financial statements before we can actually do annual return filing, which means that we actually report to the registrar that everything is all proper. So internally, right, the shareholders will have to approve what the directors have done throughout the year. And how the directors do that, they come out with a financial report. Okay, so financial statement. So this financial statement will be tabled at the annual general meeting. Okay, so if let's say there's only one individual in the company and he's both the sole director and the sole shareholder, the same person, then the requirements here of how we hold the annual general meeting would be a lot less stringent, not because we want it to be less stringent, but because there is almost no, or actually there is no possibility of the directors doing things that the shareholders would not agree to because they are the same person. Okay, so essentially, like for us, if the director say I want to hold the AGM, and the same person, we don't really mail out the notice for AGM. We actually just inform the directors, and then we just do up all the resolutions in writing, and then we get the that individual who is both the director and the shareholder to sign everything all at one go. Okay, so we also uh yeah, so if if he so called wants to hold a physical AGM, then we will also tell him that this you can dispense with the 14 days waiting period, and then we'll come out with a proper resolution. So in that sense, right, it's a bit less formal as compared to if let's say there were like 20 shareholders and then there were three directors, and these three directors were not shareholders of the company. Okay, which essentially is many times the case. So like for us, right, we have clients whereby they actually have maybe 20 shareholders. Then after that, right, they have like three directors. So these three directors, they are in charge of the day-to-day running of the company. And then um in these three directors, right, we would actually tell them that you have to adhere very strictly, and then after that do up the financial statements more rigorously. That means like previously, if it was like a one-man show, we would use like a template, and then so long as the director sign off on the financial statements, then the shareholder, which is the same person, also agree that this financial statement is okay, then we can move on already. But we have cases whereby we hold the annual general meeting for the client, then after that, we have shareholders who question the financial statements. So in those cases, right, obviously we would advise the director that we would go through the financial statements with you so that you can adequately be prepared for for the meeting with the shareholders, because essentially you are supposed to present the financial statements. Then in some cases, of course, the directors will say, you guys help me to present, so we will also attend the meeting with the directors. Okay, so these are internal matters. Okay, so like obviously, if there's only one shareholder, then there wouldn't be a shareholder agreement because who are you to agree with? Okay, you're just one person only. So obviously, there wouldn't be a shareholder agreement as well. So a lot of times, right, we tell clients that it's a lot of common sense. So later I'll elaborate what is common sense. Then the next one, right, is external matters. External matters, right, means dealing with other entities like or like the like we deal with ACRA and IRAS, or we deal with other companies. So external matters, right, pertaining to ACRA and IRAS, right, which means that no matter whether your company is big or small, right, you still have to file your annual return filing. You still have to file your corporate taxes. So these are things that you confirm must do. Okay, you cannot say that, oh, I didn't make money, or I lost money, and then after that, right, I I I don't want to so I don't need to file my corporate tax, or I don't need to file my annual return filing. So that is actually an offense. So it's inside the act, it's inside the income tax act, and it's also inside the companies act that all companies have to file their corporate taxes and their annual return filing. So these are things that you should adhere to. Okay, and then of course there are some things like registering the register of controllers. These are certain statutory requirements, right, or that the registrar might require the companies to adhere to. So these are external matters. Okay, so all these things, right, standard, whether you big or small, one man show or not, right, still need to do. So it's very important, right, that you develop this common sense idea of what is big and what is small, and then what needs to be done. Okay, so a lot of times we get clients coming to us saying that my previous corp set asked me to do all this even though I maybe I only make 50,000 only, right, then I'm a one man show, then my previous corp set asked me to be audited. Like, I don't know why you need to be audited if if it's like a one-man show and then the revenue is like quite small. So like I mentioned, right, it's a lot of common sense. You need to understand carefully, right, what may go wrong. The law is not there to be read literally, but the law is there for a purpose. So we need to read the acts, the relevant acts with a purpose. And then they're trying to decipher, I mean, they're trying to prevent certain forms of uh, certain behavior which would obviously be wrong. Like for example, misappropriation of funds, non-accountability. But so long as all these are adhered to, right, you can see that actually the law is trying to put everyone to this standard. Okay, so yeah, this is a lot of common sense. And then the statute also provides for a high level of corporate compliance when the number of shareholders or revenue of the company reaches a certain level. So like if you have 50 shareholders or if you have like 100 shareholders, okay, then you're obviously a public company. So a public company will need to be audited. So by itself, right, the public company would need to be audited. You don't need to go and make noise and say, do I need to be audited? Because public company, right, has higher level of corporate governance. Okay, so you can see that the law itself, right, provides for this. Okay, so or like the revenue of the company reaches a certain level. So obviously, if you cross like what 10 million, okay, then after that, you need to be audited. Okay, so directors must always be aware that they are responsible for the day-to-day running of the company. He cannot push the responsibilities to the company secretary. So even though the directors appoint the company secretary, right, the appointment is, the appointment is good in the sense that if you're a director of a company and you appoint a competent company secretary, right, it's part and parcel of the directors using diligence in running the company. So in that vein, right, if the director say, oh, I'm not so well versed with the running of the company, then I engage a corporate secretary, then this person will step in to assist. But at the same time, right, you also need to know if your corporate secretary is telling you that you made like a $10,000 profit, and then you're a one man one director, one shareholder company, then your corporate secretary is asking you to get your financial report, your financial statements audited, then that is that is over and above. Okay, so normally, right, for us, what we do, right, is that we try to get clients to do the necessary. I wouldn't say it's doing the bare minimum, but we normally get clients to do the necessary. Then, as we do the necessary, right, we always have in mind what is good corporate governance and what the law is trying to prevent. So in that sense, right, certain things that we tell our clients to do, like for example, adhere to annual return filing, adhere to certain deadlines, right, all these, right, is non-negotiable. Whether your company is big or small, it doesn't matter. So if let's say our company is you appoint us as your corporate secretary, so and if you're watching this video to try to allow me to explain to you what I mean, right, then you would obviously know that certain things that I tell you to do, right, you have to do. Okay, as the company, right, the company has to do. The rest, right, let's say like if there are things that we don't think that is necessary, right, we wouldn't ask you to, like, we wouldn't ask you to get your financial statements audited if there wasn't a need to for it to be audited as well. Okay, so that's all from me. If you have any queries, right, you can contact us at hello@rafflescorporateservices.com. And these are the two websites that we have. One is a corporate site, one is a front-facing client site with all our services. Okay, so that's about it. Then I'll see you guys at the next video.